Hello, this is Alex from the New York City Conflict of Interest Board coming at you with a recent COIB enforcement case. Let's get into it. The New York City Department of Education has an Office of Students in Temporary Housing. This office is composed of social workers and community aides and other kinds of staff that provide tutoring services and enrichment programs, including trips and excursions for NYC DOE students who are also homeless. There was a Queens regional manager of one of these offices of students in temporary housing, and one of her responsibilities was to chaperone kids on those excursions. She chaperoned them to Rocking Horse Ranch. She chaperoned them to the off-Broadway musical Stomp. And she chaperoned them on a trip to Niagara Falls. She also took her daughter on these trips. That's 3 violations of the New York City Conflict of Interest Law. Chapter 68 of the City Charter, the New York City Conflict of Interest Law, prohibits public servants from misusing city resources to get oneself a personal benefit or to get a personal benefit for someone associated with the public servant, like a daughter. There was a trial. The result of that trial yielded a $7,500 fine for this former public servant. The level of fine was set in reflection of the fact that this former public servant had already been terminated by the Department of Education for this misconduct. This is the 4th time that the Conflict of Interest Board has resolved a violation of a DOE employee who took their relatives on trips that were intended for students in temporary housing.